All right. I will start. So let me begin with the introduction. We want to welcome you again. We're absolutely happy to see you. We welcome all of you and your friends to join us during these bi-monthly or every 2 weeks. We're giving these instructions on various subjects that we know that you are interested in, and we want to educate you. We want to keep you abreast of what's happening in the legal world, so that the more information that you have, the more informed that you are, the better decisions that you can make. My name is Robert Galliano. I am one of 8 attorneys with Coper & Bonger. My background is I am a certified specialist in estate trust and probate law by the state of California. I have a master's degree in taxation. I'm a veterans attorney accredited. I am also able to practice before the Supreme Court of the United States. And I have been doing this thing for over 30 years. And I feel that I can answer most of your questions. I will try to answer some of them as we go through the presentation. Now, the topics for today are broken down into 3 categories. We're going to be talking about property ownership. In other words, what are the ways that we can hold ownership to real estate in California? And then we're going to be talking about what is the proper way and all of the dangers that occur when we're trying to transfer title to somebody else. And then, of course, like always, we want to offer how we can help you with your potential problems. So the title of this webinar was When Does Title Really Transfer? And before I get to that, I feel that we need to understand some very basic concepts. A lot of these basic concepts we're all familiar with, but I will try to add maybe some interesting factors that you may or may not be aware of. So the first thing that I want to talk about is why do we bother about recording title to property and so forth? California has a recording system, and the purpose of establishing the recording system in California was really to inform persons that are planning to purchase or otherwise deal with land about the ownership and condition of the title. In other words, if you want to buy a piece of title, what you want to make sure is that that particular piece of land has not been sold before, and the system is designed to protect lenders and purchasers against secret sales, transfers, or other liens that have not been undisclosed. So the purpose of the system is really to allow the title to property to be freely transferable. Now, I'm going to share a personal story with you. In the 1980s, I actually had someone sell a piece of property that I owned without my permission. I had a commercial building where I had my offices, and this other fellow had actually sold my property to somebody else. And I happened to catch it. And then when I confronted the guy, he just kind of added like, oh, it's just a mistake. But it does happen. And I just want you to know that it did happen to me. And unfortunately, I had the property correctly recorded. So I was able to quickly untangle the disaster that could have impended, because this guy actually has sold the property without my permission. Now, these are recorded. So why do we have such a recording system? What's required? Why do we have a recording system in California? This is another interesting fact that I want you to understand, and that is that we record sales, we record transfers, we record anything that has to do with title, because recording the transfers of property with a title recorder is to give notice to other people that there has been a change of ownership in the property. And California has a very interesting rule, which is called the California First in Time, First in Right rule. And what I want you to understand what this is. Now, we all know that there are people out there that are trying to commit fraud and try to steal our properties. That happens. And California has a first in time and first in right rule. What this simply means is that if you have, for example, if you buy a piece of property and you don't record it, and some other person records the interest in property ahead of you, they may actually become the first owner of the property, and you may wind up with clouds on title. You should immediately, once you purchase property, have it recorded. You want to do that so that nobody else can get ahead of you and claim that they are the owner of that particular property and that you may not have had the authority to sell the property. Now, again, we really don't have a rush to the recorder's office because that's generally, I've never seen this happen, but I do need you to be aware of that it's important that property get recorded as soon as you can because of this particular rule that we have in California. Now, I'm going to talk about the ways that you can hold property. There are several ways in California, as you can see on the screen. We have obviously sole ownership of the property. We then have joint tenancy. We have tenants in common. We have community property. We also have community property with right of survivorship. Now I'm going to cover the distinction with these different types of ownership, and I'm going to try to alert you as to some of the pros and cons that exist when we hold title under these various types. And believe it or not, these are the ways that you can hold title to property. So I need you to understand what is basically what happens when you take title under these various ways. So first of all, sole ownership. That was real easy. I, Robert, own a piece of real estate. I am the only owner. I then have the right to dispose of the property. I'm the only one that has the authority to sign the deed. I can control it. I'm responsible for the obligations. I'm responsible for the benefits. I'm responsible for the liabilities. It's my property. I'm the sole owner. I don't have to deal with anybody else. But the next way to hold title to property is joint tenancy. This is a very common way that most real estate sales are suggested that people hold title to the property that they purchase. But I want to cover what joint tenancy is. I want to cover what the advantages might be. But mainly I want to talk to you about the disadvantages of holding title to joint tenancy. It is very common, and we see this often, that maybe a parent or a grandparent will have title with a child, adult child beneficiary, because they realize that if you hold title in joint tenancy, that if one joint tenant passes away, then the other joint tenant will inherit the property, and that inheriting the property will generally avoid probate. So they look at holding title to the property in joint tenancy as a simple way to avoid probate. So let's go and see what joint tenancy is. First of all, what is it? Well, joint tenancy is when two or more individuals are joint and equal owners of the same undivided interest in the real property. It is established by having 4 unity items. The first is you must have common interest. The conveyance must be in the common title. It must be conveyed at the same time, and you must have equal possession. So there are 4 entities that are required in joint tenancy: the same interest, title, time, and possession. We all know that the most important characteristics of joint tenancy is the right of survivorship. Now, here's something interesting. The problems that we see on these is that a lot of times the description of a transfer is not identified. In other words, how is the property transferred? The property may be transferred to Jack and Jill, but they don't identify how. Was it transferred as joint tenancy? Was it transferred to tenants in common? How? And the other thing is that a lot of people think that you need to put down not only the words joint tenancy, that's required, that you also have to put down, in addition to that, the words with the right of survivorship. Those are not really necessary, or do a lot of people put that in? But just so you know, the verbiage in the deed of joint tenancy would be sufficient. Now, if one joint tenant dies, you are also familiar with the fact that the survivor joint tenants or multiple owners then will continue with the property. And you have to understand also that at the death of one of the joint tenants owners, the other joint tenant takes the property, and that is to the exclusion then of any potential beneficiary. That is to the exclusion then of any beneficiary taking ownership from the surviving joint tenant. It is very common that a lot of people have come in, for example, they hold property in joint tenancy, and then they have created a will or even a trust. And in these documents, they'll identify that the property that they currently have in joint tenancy is going to be transferred to somebody else. And that is not true. A will and a trust will not overturn the joint tenancy rule that the joint tenant who survives takes the property. It is important for you to understand that a will and a trust will not overturn the rule about joint tenancy. The deed will control. Some examples. I have a couple of questions here that have been asked already. Can you, the owner, for example, transfer the property to yourself or to somebody else as a joint tenant? Yes, you can. What if you're holding property as what if you're holding properties as tenants in common? Can you then transfer them to other joint tenants? The answer is yes. Can you transfer, for example, property that you have as community property? Can you convert that into joint tenancy? The answer to that is also yes. And there's also another question that was posed, which I think is an important question, can you transfer property to the trustees of a trust as joint tenants? And the answer to that is yes, because a lot of times you will see, can a trust be a joint tenant with another individual? And the answer to that is yes. Now, another interesting thing that's important for you to understand, how do you sever a joint tenancy? A joint tenancy is severed simply by one of the joint tenants gifting their interests to another party. And that then will sever the joint tenancy. And then the joint tenancy will be tenants in common. In other words, if you want to sever the joint tenancy, all you have to do is transfer your interest to somebody else, not to be holding joint tenancy, and then the joint tenancy will be severed. That's important to understand, because a lot of times you may have a joint tenant with you, and without your consent, they can sever the joint tenancy and transfer their interest to a third person. And guess what happens then? You wind up with a deed where you are one of the owners, and now you have somebody else that you don't even know as an owner with you on title. So one of the disadvantages is transferring without consent of the other joint tenant. That can happen. The other one is, you have a joint tenant with you. You have a child, for example, on the title with you, with mom. All tenants are going to be liable for the debts. If one of the joint tenants gets sued, if your child gets sued, for example, what's going to happen? They're going to go after that house. So having somebody else on title with you is going to put your home, for example, at the potential liability of the other issues with the mismanagement of the other joint tenant. And then there's another interesting fact, which I need you to understand, and that is that the concept of step up in basis and value, this happens when people die. What that simply means is that if you buy a piece of property for $100,000, and at the time of death, the property is now worth $1 million, the difference between the $100,000 that you paid basis and the $1 million fair market value that it is now upon your death, that's called gain. But in joint tenancy, only half of the value will be stuck in the value in the cost basis. Why? Because the other joint tenant is still alive, and that's the way joint tenancy works. So there's an income tax disadvantage in holding property in joint tenancy. It's not the best way to hold title. Now, let's talk about the next one, which is tenancy in common. What is that? Well, that's two or more individuals holding equal or unequal interest in the property. In other words, if I am tenants in common with Jack, I can have a 60% interest, Jack can have a 40% interest, and the other thing that I can do is I can transfer my interest without Jack consent. I can transfer it to a stranger, and again, we have the problem then that the person that owns the property may wind up with a partner that they do not like. Now, another disadvantage, all tenants are liable for the debts. So one of you incurs the debt, all tenants are liable for the debts. Second, each tenant in common owner can force the sale. Think about that. You are in a ownership of a piece of property as a tenant in common, and you want to keep the property for your family, and the other tenant in common wants to sell the property, and he can force the sale. How is that? That's unrealistic. And he can transfer to whomever you want. I'm going to give you another story. A mother and daughter were entitled as tenants in common. At the time, the daughter was putting pressure on the mother to sell the property. The mother was living in her home. The daughter was trying to force the mother to sell her home. Mother did not want to sell her home. The daughter kept pressuring her, influencing the mother to sell. So guess what the mother did? She came in to see me and told me about the problem. She was so upset. So here's what I recommended. It's not a general recommendation for all of you, but I just want to tell you what I did. I said, Mom, who is the person that your daughter dislikes the most? Who is the enemy of your daughter? I said, Mom, if you want to get even, transfer your interest to the enemy of your daughter, then she will wind up on title with her enemy. And let's see what happens to her life. When she has ownership of a piece of property with the worst enemy in her life, she will be in serious trouble, and you will have gotten even with your daughter. A little bit of I don't recommend doing that, but that's what happened. Well, let's talk about the next way of holding title to the property. That's called community property. Now, community property, okay, everybody talks about community property. We're one of 9 community property states. California has a community property state. That's property that's acquired during the marriage. There's a presumption that any property that's acquired during the marriage will generally consist of property that belongs to both husband and wife. Now, within also a marriage, be aware that you can also have separate property. Not every property that exists during the marriage has to be community property, because you can't have separate property that's acquired during the marriage as long as you properly identify that it's separate property. Because the minute that you start commingling separate property with your spouse, for example, you have an inheritance of $100,000, that inheritance is totally separate property. But if you commingle it with a bank account that's in the name of both of you, that's commingling, and you will be doing what's called a transmutation, which should be in writing, and it will allow then the separate property to become the community property of both of you. But you can keep separate property even though you're married, because any gift, any inheritance that's acquired, I'll repeat it, any inheritance that you acquire even though you're married is still separate property, unless you commingle it. So it's important, for example, that you understand that there is the presumption that property acquired during a valid marriage will be presumed to be community property, but that presumption can be overturned for proper evidence that you have property that was acquired, for example, from your mother in an inheritance, and that is separate property. And there are some disadvantages, and the disadvantages are obviously that there is joint financial liability. You've heard of people applying for loans where both of you sign. Then there's a default on the credit card. The credit card company is going to come after both of you because you both signed the agreement. So there's financial joint liability. And generally, if you want to act on something, if it's community property, you both want to sell the community property, you both have to consent. All right, move on. Community property also does not automatically go to the surviving spouse. And sometimes the omitted spouse may have to file a probate action to get her statutory share. So California, in the year 2001, and later in 2003 for domestic partners, the California Probate Code introduced another way of holding property in California. That's called community property with right of survivorship. Now, in this particular way of holding title, you do want to place the words with right of survivorship. Now, remember under joint tenancy, I said joint tenancy is enough. You don't have to put right of survivorship. But under the community property with right of survivorship, title ownership, you have to put down community property with right of survivorship. So what does this mean? That means that when the real property is held in community property with right of survivorship, the property will pass to the surviving partner or spouse automatically. And going back to the step-up in basis concept, which I'll repeat one more time, and that is that if I buy a piece of property for $100,000, that's basis. The property now has increased the fair market value to $1 million. That's gain. If you transfer property at death and it's community property, the entire property will be stepped up in base value. That means that the new cost basis will be stepped up from the 100,000 original to the fair market value of $1 million. There will be avoidance of capital gain. Remember, in joint tenancy, only half. In community property, it's 100%. So, what is the best way to hold title of the property? Obviously, is holding ownership of property in a trust. Why is that? Because 99% of the property held in a trust is community property. You will wind up with a full step-up in basis. You can control distribution to beneficiaries. You can identify what happens if one beneficiary dies. You can identify who are the subsequent beneficiaries. You feel control over the estate. It is much better to hold title to property in a trust. Are we clear on that? Okay, let's go to the next slide. Now, here is a couple of slides where what I'm going to do is I'm going to talk about people get confused with different terminology, and I don't blame anybody because a lot of these descriptions, a lot of legal definitions, a lot of legal descriptions, they sound the same. Medicaid, Medicare, Medi-Cal. there are differences there. But there's also some differences in property that I want you to understand. And one of them is, do you know what a homestead exemption is versus a homeowner's exemption? Now, if you look at these two definitions, there's hardly any difference in the wording. Homestead, homeowners. The word exemption is on both of them. So it's understandably easy to misconstrue which is what. So I want to clear this up. First of all, homestead exemption. What is it? Well, I'm going to tell you what that is. It is really an amount that protects the home equity in your home from creditors up to a certain amount. What is that certain amount and how did we get there? Well, here is what I'm going to tell you. In recent years, there was another bill that was passed in California, and it raised the limits of what used to be a very small amount of exemption to protection against creditors. And as of January, the numbers of January 1, 2022, the amount of the exemption protection is a whopping minimum of $313,200, and it's capped at a value of a median sales price of a home up to $626,400. So the creditor protection, it falls somewhere between the 300 and the 600,000. So here's how it works. Okay, if you have a home, for example, whose median value is $500,000, that could be the homestead exemption credit for your home. And if, for example, your home is less than $313,200, the equity, then you can claim the minimum amount. These numbers have increased dramatically simply because the values in property in California have increased. Again, the minimum exemption for 2022 is $313,200, and the maximum is $626,400. The exemption limit, again, will be the median of this home sale price of the prior year in the county where you had the home. And these figures are tied to basically to inflation numbers, and they will be increasing every year. So one other thing, the homestead exemption applies to your principal residence only, not the second homes or commercial property. And it is a protection that is available to you automatically, or you can file for it. And I recommend that everybody files for a homestead exemption in California. Now, what is the homeowner's exemption? Homeowner's exemption is a $7,000 reduction on your property tax bill. If you look at your tax bill closely, you will find an entry where it says there's a $7,000 reduction on your property tax bill. So how do you get that $7,000 reduction in tax bill? You have to file for it. Go into the, let's assume that you're in Riverside County. Well, go to the Riverside County Recorder website and then find the form for filing the homeowner exemption, and you do that, okay? Now, I want to bring another point in here, which is interesting, and I'm not going to be discussing any Prop 19 issues at this time, but I do want to clarify one thing, and this is important. Under the new Prop 19 transfers, the interrelational transfers that occur in the home, you remember under Prop 19, that if you transfer your primary home to a child, the child has to live in the home. And the way that the county recorder knows that that is what the child is doing is that he has to file for the homeowner exemption on that home that he's now occupying. And therefore, a form has to be filed when you do a transfer of your primary home under Prop 19. And in order for the child to keep the original tax bill, you will have to file a homeowner exemption. And I want you to clearly understand the difference. Homestead exemption, creditor protection. Homeowners exemption, $7,000 reduction on property tax bill. Okay. Let's talk about how do we establish property ownership. Deeds have to be in writing. The parties must be properly identified. The parties have to be competent to sign, to execute the deed. The property has to be correctly identified. There has to be a granting clause. What does that mean? It has to say, I hereby grant. There has to be a decision to transfer title. The grantor, the person who's transferring title to the grantee, has to say, I hereby grant, I hereby quitclaim. It has to be signed by the party or parties making the conveyance, and the property has to be delivered. And here's another requirement is that the property has to be accepted. It has to be creation properly executed, and it has to be delivered, and it has to be accepted. These in general, properly executed, delivered, and accepted, then a deed will transfer title to the real estate property from one person, grantor, to the other person called the grantee. Some of the transfer may be voluntary. You may want to do so. Or some of them might be involuntary, like, for example, eminent domain or foreclosure sales. Delivery and acceptance. A deed is of no effect unless it's delivered. Delivery in this context means more than simply turning over the physical possession of the document. The grantor must have the intention to pass title immediately. People have to understand that acceptance and delivery are requirements of a valid transfer on a deed. So let's move on. What are the different types of deeds? Okay, so what are we talking about here? And the thing that I want to cover here are basically the two types of deed, which are grant deeds. And in California, the two popular methods are grant deed and quitclaim deed. And the grant deed is basically really when a person transfers ownership to a new owner. You're granting it. The grantor donor promises that all the rights to the property are being transferred, that there are no hidden owners or easements. The inclusion of the word grant in the grant deed, the grantor is implying certain warrants that he or she has not already conveyed the property to any other person, and that the property is free of encumbrances. So a grant deed then is really providing additional, I'll call it guarantees. A grant deed promises to transfer the rights of the property, that there are no hidden owners, The word grant in the grant deed warrants that he or she has not already conveyed to any other person, and the estate is conveyed is free from encumbrances. Now, what's a quitclaim deed? A quitclaim deed is when the transferor or grantor transfers only the interest that the grantor has at the time of the conveyance. The grantor is not promising anything other than they are giving up their own rights. They're not granting that there are no easements. They're not granting that there's no encumbrances. They're not providing any implied warranties in connection with the quitclaim deed. It basically says, I am conveying all the title that I have in the property described in the quitclaim deed, if in fact I have any. So why do we, for example, generally use a quitclaim deed? Well, think about it. When you're transferring property from yourself to the trust, to your revocable trust, are you going to be cheating yourself? No, you're transferring the same ownership rights that you currently have. You're going to transfer the same rights over to your trust, right? So a quitclaim deed is a simple document that can be used, transferring your own interest to yourself and to your trust. That's what generally what it's used. Simply because the other thing we don't do is we don't do title searches. We don't do any we don't want you to pay for any major title searches to go back to make sure there's no encumbrances, because it's your property. You should already know what you own. You're transferring your own property to your own trust. Now, let's switch over to something else. But before I do that, I do want to talk about another thing that is called notarization. Remember at the beginning that I said that you should record your deed in order to be first in the chain of title, so nobody else can file ahead of you, following the first in time, first in rule that California has. And the question is always, why do we have to notarize a deed? Well, here's the deal. You can't record anything unless it's notarized. The deed is valid, even though you don't notarize it, but you're not going to be able to record it, so it has to be notarized. And a lot of times people have a misunderstanding. There are two types of basically, I'll call it notarizations. There's one notarization that's called acknowledgement. Acknowledgement simply means that you are acknowledging to the notary that you are the person who signed the particular instrument. In this particular case, you signed the deed. You're acknowledging that you signed the deed. You don't have to sign in front of the notary, which is another misconception. It is good practice and it should be signed in front of the notary, but there's no requirement, because the acknowledgement simply says, I acknowledge that I already signed that particular instrument, and I'm telling you, notary, that I'm the one that did it, and that's what being promised or declared. The other one is called a jurat. That's different. A jurat is something that is like under penalty of perjury. I swear that I am the one that signed the document, and that has to be signed in front of the notary. Okay, let's switch over now to another questions that I normally get in the office, and this is confusing also because remember we're talking about alphabet soup, the alphabet soup that occurs in real estate. Homeowners exemption, homeowner homestead exemption, deed of trust, deed of reconveyance, grant deed, quit deed. I mean, there's so many different terms that I want you to understand what is a very common misconception, and that is that what in the heck is a deed of trust? A lot of times when you come into the office and we're going to be funding, preparing deeds to transfer your home to your trust, we ask you to provide us with a grant deed. And a lot of times people come in and bring us copies of a deed of trust. Well, a deed of trust is not a grant deed. So what is a deed of trust? A deed of trust is the following. A deed of trust is similar to a mortgage in the sense that if the bank is going to lend you $200,000 to buy a home, they are going to want to protect that loan with the security of your property. So they file what's called a deed of trust, which is recording that there is an obligation that you owe the bank for the money that you borrowed, and therefore it is like a lien on your property. And that is called the deed of trust. Basically, similar to a mortgage, securing the obligation for you to pay back the money that you borrowed from the bank. Okay? So what is a deed of reconveyance? Once you pay the bank back the $200,000 that you borrowed to buy the home, you want to make sure that the bank files something that says they've been paid back, because you want to clear that obligation from title. You want to clear that obligation from the bank having on your home that makes people believe that you still owe the bank the money and you don't anymore because you paid it. So the deed of reconveyance is something that has to be recorded that basically says, hey, the borrower or paid the money to the bank and therefore they have clear title. Make sure deed of reconveyance is properly recorded. You need to understand, deed of trust secures the obligation of the bank. Deed of reconveyance is recorded when you have paid the bank back. A couple of other terms. You see this often in the world of estate planning, and we use this often and so forth when people come in and there's been a death or there's been a change, for example, of a management on a trust, which is the management of the trust, as you know, is done by the trustee. They're the manager of a trust, and a lot of times when there's the death of a trustee, how do you remove the trustee? How do you put in place the successor trustee? And that's what is called an affidavit. What does an affidavit mean? It's simply a declaration. It's a declaration, affidavit, declaration. I'm declaring that there's been a death of a trustee. I'm filing an affidavit that there's been a death of a trustee. This document, what it does is it will remove the deceased trustee and allow the successor trustee to take over. Something that has to be filed, recorded, because if we don't clear the title of a deceased trustee, and then you try to use your trust, for example, to open up a financial account with a financial institution, they will want to know who is the acting trustee, and therefore having the affidavit of death of trustee would really reflect that, hey, that other trustee died, I'm now taking over. Very important document to prepare and have. What's the other one? Affidavit of death of joint tenant. When people hold title to property in joint tenancy, everybody knows that when one joint tenant dies, the other joint tenant inherits the property by operation of law. And a lot of you think that there's nothing that has to be done to clear title on that property. And the answer is yes, you do. You have to file a declaration, an affidavit, that one of the joint tenant dies and that you have removed the deceased joint tenant from title and you are the surviving joint tenant. Now you are the sole owner of the property. Very important documents that have to be created. Now, let's talk about recordation, okay? It is very important, okay, that we talk about recording a deed, why we have to record a deed. I've discussed this before. I'm going to talk to you about it again because it's important that we understand why recordation is important. Again, recordation, as we know, right, first time rule in California, you have to make sure that you record the deed And there is another point that I want to make is that simply because you record the deed, that does not affect its validity, because the people at the recorder's office, they will pretty much record any document that appears to be 100% correct, that affects property, will be recorded. So a lot of times, recording a deed will be done even if the deed is incorrect. Even if the deed is invalid, it may be recorded. And recording a deed does not affect its validity, and therefore you have to be careful that you don't fall, or you don't have this false sense of safety that, oh, I recorded a deed, everything is followed. The recordation, what it does is, it is protection. Remember, it's protecting you, that basically you are the owner of the property, and therefore nobody else can jump ahead of you and try to record ahead of you. So you have to record immediately, okay? Failure to record and any other deed affecting the title that's recorded ahead of you is going to put you in jeopardy. So while recording a deed, again, does not affect validity, it's extremely important to record, since recordation will protect the person who owns the property. If a grantee fails to record and another deed or any other document encumbering or affecting title is recorded, the first grantee may be in jeopardy. Again, important for recording property is clear. Now, what are some of the problems that we encounter with property? We see a lot of deeds created by other companies, other institutions, and they will have the transfer from the owners of the property to a trust, and they do not have the correct title of the trust. The correct title of the trust should really be the name of the trust and the date of the trust. The Johnson Family Trust, dated January 1, 2023. Why do you want the date of the trust on the title? Because there might be many Johnsons and there might be many Davids around, and there can be confusion as to who is the real owner of that particular trust. Second, if the owner of the original property is, let's assume, Samuel Johnson, he has to transfer or sign the deed transferring that particular piece of property to the grantee. He has to sign it Samuel Johnson, not Sam Johnson. The name of the property that's on the original deed, that's exactly the person or the name that has to transfer the property to the subsequent owner. You can't have Samantha Johnson owning the property and then she signs the deed to transfer the property as Sam Johnson. Variation in names of the grantee and grantor and instruments causes problems. And you wind up having to prove that Samantha Johnson is really the person, Sam Johnson, and then you wind up with having to provide what we call off-record evidence, the names, and trying to prove that Samantha is the real Sam and so forth. You're going to wind up in another court proceeding and other arguments, and all of this difference in names and everything may render the title totally defective. That's another very important thing to understand. So we are very careful that when you come to us and we transfer property to your trust, we want to make sure and we do verify that the original name of the owner of the property is the person who signed the property to transfer to the new owner. Another one, incorrect property description. You want to make sure that you are transferred or you are transferred the property to your trust that is your property. If you are describing your neighbor's property in your trust. And when you die, your trust is transferring your neighbor's property. What do you think is going to happen? Problems. Another one. Interest rates go up and down. Several years ago, we had the opportunity to refinance our property and get maybe a 2 or 3% interest rate, which is fantastic. A lot of you may have done it. But a lot of times the lender has required you to take the ownership of your home out of the trust and put it into your name as individuals before they refinance the home. And guess what? Some of you have forgotten to retitle the property back into your trust. What do you think is going to happen if you hold title to your home in your own name? Even though you have a trust, you're going to wind up in probate. Title transfers. When does title transfer during life? Generally, when the deed is signed, but a deed has no effect unless delivered, and there has to be acceptance. There's a rebuttable presumption that the delivery of the deed, as long as it's found in the possession of the grantee or has been recorded, is that it has been delivered and is presumed to have been delivered as the date that it got recorded, and generally when possession or rights are given when the deed is delivered. So generally when you do a normal real estate transaction, the signing of the deed, the transfer or the transfer that occurs of the recording in escrow is the delivery and acceptance of the deed. So that pretty much under normal circumstances, the procedure does accomplish the proper signing, proper execution, the delivery and acceptance. All right, one more. Let's go on. I do want to cover this because this is important for you to know is when does ownership of property really transfer? On sales, generally when the property is recorded. On leases, when there is a right of possession established. On inheritance, date of death. This is important because a lot of times people think that when you inherit property and you inherit property, that you have to prepare a deed and record it before the title has transferred. That is not true. In California, upon death, that is when title is transferred. What happens when you have property and revocable trust? Property transfers when the trust becomes irrevocable. When does the trust become irrevocable? Generally, when there is the death of the first or last, not the first, but the last creator, settlor. If it's single settlor, when he dies. If it's a husband or wife settlor, generally when the second settlor dies, the trust becomes irrevocable. The death, that's when it becomes. That's when title transfers. When does title transfer? When you are dealing with an irrevocable trust. That's different. That's the date when you put the property in the trust. So the fact that there is different times and condition as to when property actually transferred is critical for you to understand how these transfers occur. We deal with this all the time. We want to make sure that you are not incurring any type of deed problems. For example, when the property is not correctly described, when you have not identified how the property is owned. In other words, are you holding the property as a joint tenant, or you transfer the property as community property, or you transfer the property? How are you transferring property? A lot of times simply saying that I'm transferring my property, Jack and Jill, without identifying how the property is going to be owned is deadly. incorrect granting language. You have to make sure that you have the proper granting language, and you have to make sure that it's properly executed. We don't want you to have deed problems, because deed problems will surface when there's been a death and there's been what we call a trust administration. So how can we help? Well, we want to do these presentations for you so that we can keep you informed. Our job is to educate you. Our job is to keep you informed, because I am of the thought that if you are more aware and educated and understand the options, you can make better decisions. My job is to educate you. My job is to provide you with information. My job is to provide you with things that you may not know. They're not so obvious. And we want your estate plan to always be perfect. And we want to make sure that you see us on a regular basis. We want to make sure that we review how title problems are avoided. We want to make sure that multiple property owner issues are not there. We want to make sure that the deeds that are prepared by other institutions are correct. Your home is one of the most valuable assets. You have to protect it. So we are, as you know, Koper Barger and Poker Barger. We've been around since 1979. There's 8 of us, 2 attorneys of counsel and a CPA. What I tell everybody is, you hire one of us, you hire all of us. If you combine all of our experience, we have over 350 years of combined experience. Half of us are certified specialists in probate, estate planning, and trust law. We have advanced tax degrees. We have a fantastic staff, qualified support staff, paralegals, fantastic, intelligent people. And in addition to that, we also have a lot of these paralegals that are going to school to get other degrees to become attorneys. We believe in education. We believe in being highly educated. We specialize. We only deal in one thing. That one thing is estate planning, probate, trust administration. We do not do divorce. We do not do criminal law. We do not do bankruptcy law. We are specialists, and we have 8 office locations. And for example, under rainy conditions, we hold Zoom discussions. We can call you on the phone, and we are here to help you. I would love to hear from you. Any questions that I may not have answered or so forth, just write me an email. I will get back with you. I'll talk to you personally on it. We have a team of people standing by to assist you with questions. You can go into the Q&A. You can place your questions there, and we will also be, I'm telling you, I will respond to all the questions that may not have been answered and so forth. We would like to be hearing from you, and I think that I have 1 minute before I complete my 1 hour, and I will take advantage of that 1 minute. To thank you. It has been my pleasure to be with you. And I thank you so much for being with me. And we are here again to help you. And with that, I'm going to bid you goodbye. And I hope you have a pleasant day.